Now that we've laid the foundation for international human rights system, as well as lands and properties place in that system, let's talk about country-specific examples. The first topic I'd like to mention is a specific land rights case that was in Nicaragua under the Inter-American Court of Human Rights, the Awas-Tingui case. Awas-Tingui was the first legally binding decision by an international tribunal that upheld the collective land and resource rights of the indigenous people. It was heard by the Inter-American Court of Human Rights in 2001, related to property rights of Awas-Tingui, which is an indigenous group in the coastal region of Nicaragua. At issue was the government's granting of logging concessions to a foreign company within the community's traditional lands, and by doing so, failing to adequately recognize or protect the community's customary land tenure. The court found that while Nicaragua's constitution and laws were progressive in recognizing the rights of indigenous people, the government's inability or unwillingness to ensure that such protection was both available and effective in practice raised important violations. The court states, in the absence of official title to ancestral land, possession of land should suffice for indigenous communities lacking formal title to obtain official recognition of that property. The Awas-Tingui case in 2001 was a landmark case within the Inter-American Court of Human Rights, Inter-American System for Human Rights, but it also had repercussions across different regional human rights bodies. Other cases followed Awas-Tingui within the Inter-American system that recognized indigenous native forms of land tenure. And in 2010, the African Commission on People and Human Rights used a lot of the language and the legal reasoning to declare a case in favor of the Andoroy in Kenya. We'll watch a brief video on that too.
Jang bichu chigi menye laini chigi nyor chibe tunoe
la ko kingo kapwa county council KWS ko chengene araita ako sakan ko chop lek pokoria kemer saf ko kingo chop ko ma mowich kala side ka servikas kelenje ke ko no propinek chebo korak ke bolo ngaraita ku ye ke bolo ngaraita bas ko pi joto ko ip ko amung ko fundi kiting toy chege ko chi kwanyon akanyon ko ko pale je chu nguno ko iro le ke chengene korak akanyon tu kala ki chang chebo to rais
kogi bago ko tiritis kyagi ke serja tata nyon gelya nge chengata tugus tikyamai o cho bu yom so tamo magitinye bek chikororon chirote chebo maisa karge tebyanyon kityo ko nyaroti tu kyagi ke sutei kelyongini kenye yisalak arandomi unomi ba yebe siak tike ko ba ko igestoni welin alak ni sarang richo bek chibune momi be kongi nyor sine so ta ge ngai sai suru iwe ko maram di momi gen gai ke yo ko besi yo ko roban sine so ko ke batam bare momi ta gen gele ne gai ni ka sa ge misu ma che mo tinye lak ta sap
lege ito lagi giyan kasya ka tul
mi pi ki sirto ako pi chu ki sirto ko ki gutu be molina ako kingo ka gutu pi chu ko is ke bisto ko no kora ko mi ger che ki jam po shengara arai nae ke bisto tol amo ke kerech ni matin ke chut
mi loy nigi getech loji nigi getech ko amu kigitara cheni gele mane bitu biji ya gasi ko biga bioy laini gile ni we toben nguno ako ngo gasi ni yo la chi cho che ko chetilo te susue Ako inguni ko tukon cho kaunti soli chege ma chutu rais rabisiek cho kotoben. Ako kikiro kele kichanga rabinik chichutu komie.
No bote alen dot kusomanya lagok choche. Wakunyoru en kasit na is boisionik kandoinat. Kuang nole ko ke kororonitu is. Makitinye serikali.
Lakini mache turois ku iwetoben ko makitinyache. Iwetoben ku barabarosiek ko ile chekwake iche ku koron mara kintene lam lakini nenyona ache ko maintene chilam. Ketinye tuguk chekibene serikali chekimuche kondenowech lam, kimuche kotekwech sukul kobolwech beek.
Kinyasonya sensene nga.
Kwa kibagenge keyumkei ake ansa keserta paronaik amu kokenais keser paronaik keser komeche mandab turois lakini kele kole usorchini bunu waldage au nyuko mutugu ololo makiyane kinuno ko ineteni
Union Commission ilisema recommend A. Recognize rights of ownership to the Endorois and restitute Endorois ancestral land. B. Ensure that the Endorois community has unrestricted access to Lake Bogoria and surrounding sites for religious and cultural rights for grazing their cattle. C. Pay adequate compensation to the community for all the loss suffered. D. Pay royalties to the Endorois for existing economic activities and ensure that they benefit from employment possibilities within the reserve.
It's all our role to conserve the trees and the water bodies around us, never pollute them, for they're important now and for the future. Thank you.
It is not only victory for Endorois, but all the minorities and indigenous people of the world.
So in February 2010, the African Union adopted the ruling of the Andoroi Welfare Council versus Kenya, the first indigenous land right claim to ever succeed before the African Commission on Human and People's Rights. The ruling marked the culmination of 40 years of struggle led by the Andoroi community, which in 1973 was dispossessed of ancestral land it had occupied since time immemorial in the Lake Bogoria region in the Kenya's Rift Valley. Since then, the land has become demarcated for the purposes of a wildlife reserve. The Africa Commission accepted the argument that the Andoroi are an indigenous community and that their ancestral and collective use of land is worthy of legal recognition. The case is unique, unprecedented in its recognition of indigenous peoples' collective rights within the African context. For the first time since the Charter was adopted, the African Commission recognized that those maintaining a traditional way of life that is dependent on ancestral land are indigenous in the African context and thus require adequate protection. This evolution development in the Inter-American, the African Commission, as well as you start to see this in certain European Court of Human Rights rulings, has changed the landscape on recognition of property rights and land rights, particularly with regards to indigenous native groups. There's also a number of important national human rights rulings as well, where different courts, different nations' courts have decided in recognition of indigenous or tribal land rights, and therefore have expanded what is considered valid tenure or valid ownership. I'm just going to highlight a few of a litany of different national human rights cases. What's really interesting about these cases, in some too, is that they cut across different countries, and countries, particularly those in the Commonwealth, former British colonies, have looked towards the decisions of other Supreme Courts in different countries and leaned on those decisions, used them to come and make their own interpretations of national law. The first case Another watershed case was the Mabo versus Queensland case by the Australian High Court in 1992. It was a sweeping decision that recognized native title in Australia as a common law doctrine and overruled terra nullius. Terra nullius is a concept that was established during the colonial period that claimed that unused, unoccupied land was land of no one and therefore was found by the Crown and became Crown-owned land. The Mabo case had three major declarations. Australia was not terra nullius when the British acquired sovereignty in 1788. It was occupied by Aboriginal and Torres Strait Islander people. These people, the Aboriginal and Torres Strait Islander people, had rights in the land they occupied at the time of annexation of the British Crown, and these rights could survive the acquisition of sovereignty by the British Crown in accordance with the doctrine of continuity. Subsequent cases have used similar language in their rulings. The Delgamuukw case in Canada, the court reaffirmed the validity of Aboriginal title and refined the test of native title to three different prongs. In the Sogong case in Malaysia, when the Malay Peninsula was colonized, a Torrens land system was introduced and all unclaimed land became Crown land. In this case, the court disagreed with the state and adopted the stance that native title exists under common law and therefore that the government has to compensate the loss of an indigenous group, the Temwan, for their homes and crops that were destroyed when a highway was built to connect to the international airport. More recently, in 2014, in the Silicate Nation versus British Columbia, the court confirmed that the doctrine of terra nullius is never applied to Canada. It affirmed the territorial nature of Aboriginal title and rejected the legal test advanced by Canada and the provinces based on small spots or site-specific occupation. The court overturned the Court of Appeals' prior ruling that proof of Aboriginal title requires intensive use of definite tracts of land and granted a declaration that British Columbia breached its duty to consult the Silicate with regard to its forestry authorizations. These national rulings, as well as the international rulings, are important for development programming. They're important for consideration of national policy around land and property rights. I want to talk now about a few different programming examples and considerations on land and human rights. Let's look first at land rights in conflict environments. Over the past many decades, there's been an evolution of understanding of land and property rights in a humanitarian context. This culminated in 2005 with the UN Principles on Housing and Property Restitution for Refugees and Displaced Persons, otherwise known as the Pinheiro Principles. They were established to create an international standard for the rights of refugees and displaced persons to return not only to their countries when they see fit, but also to their original homes and lands as well. The Pinheiro Principles state, all refugees and displaced persons have the right to have restored to them any housing, land or property of which they were arbitrarily or unlawfully deprived, or to be compensated for any housing, land, and or property that is factually impossible to restore as determined by an independent impartial tribunal. There's many different forms of reparation for returning refugees and IDPs. Land restitution is only part of that reparation picture. There are important land restitution lessons from other countries such as Bosnia, South Africa, and Guatemala that have recently gone through post-conflict reparation. We'll talk about these a little more in an upcoming module that looks more specifically at land and conflict and post-conflict situations. A couple of general principles I'll lay out here that will apply to the next country example on the next slide. First off, one of the lessons was restitution should not be conditioned on return, that it jeopardizes the fundamental right of all victims of displacement to a remedy. In many mass restitution settings, administrative procedures are the most effective and most likely to bring some type of reparation to victims. In South Africa, the restitution process found that early judicial proceedings under a specialized land court had to be abandoned in favor of a nimbler administrative process that was more suited to negotiation-based nature of restitution. This has been an important topic to understand a little better for my own work in Colombia on human rights, on a USAID-funded human rights project, but also in support of larger efforts within Colombia by the government to restitute land to victims of the protracted civil war. Currently in Colombia, there's a restitution unit that has been established with the purpose of returning land to victims that have been displaced. This restitution unit was established as a new agency within Colombia and has had a difficult process in moving forward with restitution in Colombia. It's a complex topic, and there's many different approaches to looking at restitution. There was a recent court case from the Inter-American Court of Human Rights in Colombia that affected land restitution. This is where you kind of see the nexus of international human rights, in particular the international human rights bodies, and national land and property issues coming together. The Operation Genesis case, the Inter-American Court of Human Rights decided in 2013 that over 4,000 people were displaced by joint military and paramilitary operations in Colombia. The court ruled that the state is responsible for violating the collective property rights of Afro-Colombian communities and ordered the state to restitute their lands. This has had an effect on the restitution policies within Colombia. There are now collective forms of reparation that the state is looking at for Afro-Colombian communities, recognizing their specific forms of tenure and ownership over land, often in a communal sense. There's other lessons that can be taken for restitution from what's happened in other post-conflict scenarios. Mass restitution seems to be more effective in transitional justice settings, and we've seen these complications in Colombia, where there's a number of mass displacement and the returning of people to their land would be more effective in a collective mass administrative form of restitution. But the Colombian system that was set up is much more judicial. And so there's been complications in establishing what would be an administrative pathway that didn't have to go through the long, lengthy process of looking at restitution in the courts. A lot of the international human rights decisions on land, particularly indigenous communities, raises an important topic about land and human rights and its implications for development programming. In particular, it highlights the need to consider and be extra careful of the potentially subjugated, almost invisible rights of marginalized groups, including women, including indigenous populations. As you can see from the cases we've outlined, as well as the different treaties and documents, these rights are now much more clearly defined in international legal framework. States have an obligation, a clear obligation now to protect these property and land rights. But some countries still need to reform their national laws to recognize the land rights of marginalized groups, particularly indigenous or customary land tenure systems that accord rights that have not been codified. This is a topic that I've looked at a lot in my work in land rights, is working with countries to identify where their legal systems, their laws, are not in accordance with international human rights obligations with regards to indigenous land rights or customary land rights. At the same time, customary laws and practices can be a source of rights protection, and they can also be a source of rights violations, particularly with regards to women's land rights and ownerships. So it's appropriate to recognize the collective customary rights of indigenous groups while also identifying violations of individual women's rights within customary law. There are other important implications for land and human rights in development programming, in particular the state's obligations to protect land and property rights. A lot of the work that's done in development or in international assistance involves state institution building. These efforts should emphasize the importance of land rights, both from an inclusive economic growth standpoint, but also through a state's obligation to protect the rights of their citizens, including their land and property rights. Some of the work that we do includes support to drafting of laws on eminent domain, but eminent domain that includes human rights principles, and some of the human rights principles we mentioned earlier, where about expropriation of land has to be done in the public interest or with just compensation. Some of these are embodied in the charters, the regional human rights charters, with regards to property. Drafting laws and legislation and policy is only part of the solution. A lot of the work we also do in development is supporting institutions such as courts that are responsible for the enforcement of these laws and human rights. This is an example of where the voluntary guidelines can provide a clear path towards states for responsible land governance that meets both economic growth obligations, interest, and human rights. The voluntary guidelines can also assist in development programming and design of policies and foreign assistance. It provides principles on land markets, transfers of land, investment, including consultation, proper consultation with local communities, redistribution, expropriation and compensation, and the creation of effective land administration systems that allow for land valuation and taxation. It also details disputes around resolution of land. There's a lot of complications with land rights, land and human rights in relation to investment. There's been a lot of press recently about land grabbing, large-scale land acquisition. And it's important to understand some of the potential background in relation to that and some of the complications, both from an international human rights perspective, but also from a national law perspective. Large-scale land acquisitions are a complicated matter in a lot of countries. They're oftentimes governed by national laws in relation to eminent domain, which provide for when a government can expropriate land, private land, from its citizens. And typically that's done when it's considered in the public interest and with the provision of just compensation. And a lot of this language is also the language that we've seen in the regional and international charters for human rights, discussing expropriation in the public interest. However, when you look at expropriation of land for investment purposes, or for conservation purposes, such as in the Anderoy case in Kenya to form a park, it gets messy. There's oftentimes a lot of different complications in the national setting. What is considered in the public interest, for example? Is a creation of a national park, is that in the public interest? Is the creation of a large rice farm that will provide jobs and food, is that in the public interest? How can you justify, or how can the state justify expropriation? And oftentimes this determination is left up to national courts, as it should be. But there are examples where the decision of a national court is then challenged or at the international level. This is a little bit of what you saw in the Anderoy case. But in the Anderoy case, it was more about just compensation. So let's talk a little bit about that principle as well. So when a piece of land is expropriated by the government for investment purposes, development purposes, or for creation of a national park, or in the case of the Awastingni, where a right to extract timber was given to a government even though it was on the land of the indigenous tribe. Once the question of ownership is established, and it's established that it's in the public interest to expropriate that land, how then do you determine just compensation? In a lot of contexts, a lot of countries, there's not a well-developed land market and well-developed land valuation schemes which you can clearly identify a value to that land. In other contexts, a lot of the land tenure arrangement, who owns what, is not well developed. It's informal, or it has never been fully established. So how do you determine just compensation when there's only informal ownership or possession of land? So it can get tricky, and these are things to consider when looking at development programming. There are other implications of human rights for investment. Recently, the Ruggie Principles were established. These are the UN Guiding Principles on Business and Human Rights, 2011. The foundational principle of the Ruggie Principles is that business enterprises should respect human rights. This means they should avoid infringing on the human rights of others and should address adverse human rights impacts which they are involved in. This extends to land as well. It suggests that businesses should establish operational policy on protecting human rights. They should conduct due diligence on potential human rights impacts. And they should try to remediate any violation of human rights that were caused by them or that they contributed to. This is extremely important, this due diligence in relation to land rights as well. As we were talking about, there's different complications on who owns land, whether it's informal or customary, what's the basis of their ownership, and then what is the compensation that should be provided based on their level of ownership. The Ruggie Principles supports this as well. The principles for responsible agricultural investment were established in 2014. It also emphasizes responsible investment with a focus on smallholder producers and establishes 10 different principles that businesses and governments should consider when looking at development investments. Among these principles are, will this investment contribute to food security and nutrition? Will it contribute to sustainable and inclusive economic development? And then the principles provide some guidance on how to comply with rights obligations in the context of investments.